Hi, my name is Denise Gilmore, and I'm a field director here with AFSCME Maryland Council 3. We are doing this presentation today because over the last 6 months during this pandemic, we've received a lot of phone calls from our members asking about what their rights and protections are during this pandemic, particularly if they are immunocompromised. So we are thankful to be joined today with Heather Heilman. She is an attorney with the law firm of Conn Smith & Collins. And we are going to go over some of these frequently asked questions. We know that this pandemic has been particularly challenging on immunocompromised workers who are understandably so concerned about their exposure risk returning to work. And so we have brought in Heather to help explain some of the federal laws that are at play here, and so that our members have a little bit more guidance, heading into those conversations that they have to have with their employer. So we're going to go ahead and jump in with our first question that's been submitted here. And the question is there a legal definition for immunocompromised, either through like the Americans with Disabilities Act or the CDC, or what types of conditions may qualify me for an accommodation? So Heather, you want to take that one away?
Sure, absolutely. So under the Americans with Disabilities Act, there's a definition of disabilities, which is a condition, a physical or mental impairment that substantially limits a major life activity. And you can have the right to an accommodation if you have that kind of disability, if you are nevertheless able to fulfill the essential functions of your job. So even though, way back when the ADA first came online, we weren't necessarily thinking about using it to address a situation like the COVID pandemic that we're in now. Nevertheless, the EEOC has recognized that those underlying health conditions that can put a person at higher risk for developing serious symptoms or complications from COVID, those conditions can be considered a disability under the ADA. And if you have one of those conditions, you might be entitled to an accommodation. And the only reason I say might is because in these situations, the analysis is very fact dependent on the individual situation. So if I'm saying something that makes you think you might need an accommodation or you might be entitled to an accommodation, by all means that you should ask for one. But just understand that it depends on your situation. You may not get an accommodation, or you may not get the accommodation you asked for. But nevertheless, being immunocompromised is one of the situations that the CDC has identified as putting you at higher risk for complications due to COVID. Actually, they only for sure recognize the being immunocompromised as being definitely a risk factor if the immunocompromised situation is because of an organ transplant. But they also at least think that other reasons that you might be immunocompromised can also put you at risk. So if you're immunocompromised for any reason, I would certainly recommend that you at least ask for the accommodation.
So then going along with that, this is a question we get quite often from our members too. And it's, a doctor has said that I'm immunocompromised, but my boss wants me to come into work. Right, especially with all the reopening that's happening right now. What can a member do in that instance? What process should they engage with their employer?
So you should definitely ask for an accommodation, and under the law, that doesn't have to be informal at all. All you really have to say is to tell your supervisor, "Hey, I need this or that." But in order to remove ambiguity and make it as clear as possible, I would put it in writing. I would use the word, "I'm looking for a reasonable accommodation," and I would also send that writing to everybody, including your immediate supervisor, the HR office. If you're working at a state agency that has its own EEO office, I would send it to them. And they're going to ask you for information about your healthcare or your health situation. So it's probably a good idea to be armed with that ahead of time and go talk to your doctor first and tell your doctor that I'm going to ask for an accommodation, and can you just write me a letter that explains what my health condition is and why it is I need this accommodation.
That sounds like we want to, first step is documenting the request with your employee.
Right. And, because there can be some, even though in theory you can just orally ask your boss, they might not understand what it is you're asking for.
Right.
So, be prepared and put it in writing and submit your request everywhere that you could think. And that prevents it from falling through the cracks and makes it more likely that your request will be dealt with quickly.
Gotcha. And question number 3 then, what types of special accommodations can an employee request? Can they request telework as part of that accommodation?
Absolutely. And I think for probably a lot of people, telework would be the best accommodation. And you should always ask for what it is that you think you want and need. Just understand that once you make the request, you're going to go through what they call an interactive process with your workplace, where they're going to ask for more information about your health situation, and they're going to look at the requirements of your job. And they're not necessarily required to give you telework, even though that's what you've asked for. But I think in the majority of situations, if you have a job that can be done from home, I would think that that's a very reasonable accommodation. I wanted to go back to and mention there's a really good website and a really good organization called JAN, the Job Accommodation Network, and I think their website is askjan.org, and they exist solely for the purpose of helping employees and employers arrive at an accommodation. So if you have questions, you can always call them or contact them, and it's free to use their service. So if you're having a hard time figuring out what the right accommodation is for your situation, that's something that you can turn to try to get some ideas and get some help with that.
Helpful. And then, so once I put in, or once an employee puts in an accommodation, what is the employer's obligation at that point once they put in the request?
Right. So I mentioned that interactive process. So they just have to talk to you about it. They have the right to request more information about your health condition. They'll also go back and look at what your job requires and see what it is that they can do to accommodate you. One of the difficulties is under the law, there's no time frame for how long this process has to take or when they have to get back to you. But obviously in the world of COVID, we're all trying to get things done a little bit quicker, and trying to get a response in a timely way. So that's one of the reasons why I recommended, papering the world with your request so that somebody notices and takes it seriously and gets on it quickly.
Can the employer deny a request for an accommodation, or what grounds would they have to deny it?
They can deny a particular accommodation, but if you truly do fit the ADA definition of a disabled person who is able to perform your job, they have to give you an accommodation. So if they deny that altogether, that's an issue, and we can talk about what you do if that happens.
Let's say that I have, an employee has put in a request, but management isn't responding in a timely manner, or management hasn't engaged in this interactive process that you've just told us about. Or let's say they have, but we feel like, we've been unfairly denied.
Okay.
What's the next step then?
Okay, so 2 things. One, if they're just ignoring you, I would recommend that you actually contact the union, contact AFSCME about filing a grievance. Now, this is not normally, I think AFSCME doesn't normally get involved in accommodation requests because it's really a matter of federal law rather than your union contract or state law. However, there are some threads I think that the union can pull, at least to try to get the employer to take it seriously or to respond to you quickly. So I would recommend that if there's issues with even getting them to notice your request, definitely contact the union. Another thing you could do if you're being denied, obviously, this is a matter of both federal and state law. The EEOC really enforces this law, so you can file a complaint either with the EEOC or the Maryland Commission on Civil Rights, which shares responsibility for enforcement. That's a longer process, but definitely if you've been denied and you believe you truly are owed an accommodation, you should definitely consider filing a complaint.
Yeah, I can back you up on Again, we don't generally, put in grievance on denials. We do encourage folks to go through those EEO
Right,
processes,
right,
but when an employee has just been outright ignored, we
right.
do find that, sometimes we do, when we put in a grievance, it'll at least trigger that interactive
Exactly, right.
process. So this is a question we get quite a bit as well. If I have put in a request for an accommodation and my employer is considering it, do I have to come into work, or do I have to perform those work duties while the request is being considered?
This is a hard question, and and I want to tell people that they're free to stay at home, but unfortunately, the federal agencies who enforce leave laws are not interpreting the laws in the ways that I would like. So, um, for example, you cannot use FMLA just because you want to try to avoid getting sick with COVID, right? However, if you do, and this is not a clear area of the law, but if you truly do know yourself to be at a higher risk, um, I think it's probably worth asking for. If you have one of those health conditions, probably it's worth at least asking for, telling your employer that you want to take FMLA and see what happens. Um, if you can go to work, and if there are some safety precautions in place that do provide you with some protection, from a work preservation standpoint, it might be better to just go in and do the job. But that's a really an individual analysis. But just be aware that it's not clear to what degree FMLA is going to protect you. And then, as you probably know, there's some even additional paid leave available for people who are affected by COVID. But unfortunately, that only kicks in if you actually have it, or a doctor has told you to quarantine, or you're taking care of your child or somebody who has COVID. So um, it pains me to say that, that the protections are not there if you feel like it's not safe for you to go to work. Um, but I would just, if you know you have that health condition, I would ask for FMLA, and if you don't, I would do what you need to do to protect yourself and just go to work. And so the general duty clause is basically a requirement in OSHA, and I understand also just in union contracts sometimes it says that um, that the employer has the responsibility providing a workplace that's free from hazards that are causing or likely to cause death or serious physical harm. And if an employee goes to work and they're being asked to work in conditions that present an imminent risk of death or serious bodily harm, how's that? That there is a right to refuse work. I would caution, and this might be an analysis that is different depending on where it is that you're going to work. But I would say, in most cases, a basic office environment is probably not going to rise to that level of being a risk of imminent death or serious bodily harm. And therefore that provision is not going to kick in. The other problem too is that OSHA, which is the federal agency that oversees this whole sort of body of the law, has kind of dropped the ball a little bit on this issue. So they've issued guidelines about how an employer can make the workplace safer, but these don't have the power of regulations or of law.
Makes sense.
Yeah.
And then I think the final question that we've been getting a lot here at Council 3 is if performance measures automatically change when an employee receives a special accommodation.
Yeah, it doesn't automatically change, but if you ask for that as part of your accommodation, then that can be part of your accommodation.
Gotcha.
Yeah.
Gotcha. So an example would be, if I'm an employee and let's use the telework example, right?
Mm-hmm.
And the telework is part of my accommodation that the employer has approved. The standard should be that I'm still evaluated, as I was being evaluated beforehand,
Right.
unless I were to request, I don't know, different,
Right.
hours or a different
Right.
quota or something as part of the
Right.
accommodation. Well, this was very helpful. I think we covered the top 10 questions that our office has been receiving. Obviously, we want to see all of our members, be able to work and return home safely. And we certainly understand that this pandemic has, provided a particularly vulnerable position for members who may be immunocompromised. So we appreciate this guidance, Heather.
I hope that this is helpful. And if you think you're owed, if somebody thinks they're owed an accommodation, certainly by all means you should ask for one. But I just want to emphasize, though, that I can't give, I'm not giving advice about any particular situation because it all very much depends on the individual details and facts.